Hi, intellectuals. Welcome to the series of International Law through multiple choice questions. In this video, we will learn about what are the various essential elements of a valid international custom. The question is, which of the following are essential elements of a valid international custom? 1. Constant and uniform state practice. 2. Generality of practice. 3. Jus cogens. 4. Opinio juris. There are 4 codes given, that is, code A is 1 alone, code B is 3 and 4, code C 1, 2 and 4, code D 1, 2, 3 and 4. So before getting into the question specifically, let us now first understand what is meant by a custom. So what is a custom? That is, in any primitive society, there would have been certain rules of behavior which would have emerged by time, and it would have prescribed what is permitted and what is not. So these rules develop almost subconsciously within the group and are maintained by the members of the group, especially by social pressures and with the aid of various other more tangible implements. These rules, at least in the early stages, would not have been written down or codified. They would have survived ultimately because of what can be called an aura of historical legitimacy. And as the community develops, it will modernize its code of behavior by the creation of a legal machinery, such as courts and legislature. The custom can be regarded as an authentic expression of the needs and values of the community at any given time. To put in even more simple terms, the term custom means achara or usage, that is, a traditionally followed long practice by the members of a society. A custom to be valid, there are certain ingredients or essential elements which are to be satisfied, such as long duration, or it should have been from a very ancient period, that is time immemorial. It should be moral and reasonable. It should be uniform and consistent. There should be generality of practice, and the last one being opinio juris. But however, the condition that a custom to be valid, it should be practiced for a long duration, is not strictly necessary when it comes to international law. Though in municipal law, it is necessary that the custom must be of long duration, that is ancient and time immemorial. What is the significance of custom with respect to international law? The sources of international law are listed in Article 38, Clause 1 of the Statute of International Code of Justice. In that, in Clause 1, Subclause B, custom is recognized as a source of international law. The custom in its legal sense involves something more than a habit or usage. That is, a usage which is left by those who follow it to be an obligatory one. And in interpretation of treaties, reference is frequently made to customs in case of any doubt. Now, going back to the conditions listed in the question, the first one is constant and uniform state practice. That is, a custom to be applied in international law, it must be uniform. That is, it must not vary or differ from state to state. And further, it should also be consistent with the practice of the states in question. The same was observed by the International Court of Justice in asylum case, that is Colombia versus Peru. In that, the court observed that the custom should be in accordance with a constant and uniform usage practiced by the states in question. The brief facts of the case would be that there would have been a rebellion which took place in Peru in 1948. Hayadila Tora was a Peruvian subject and a political leader who was charged with rebellion. Colombia would have granted him asylum in her embassy in Peru, which is an extraterritorial asylum, and it also requested the Peruvian government to provide facility to take him outside Peru for Colombia. The request was made by Colombia on the basis of Bolivian Agreement and Pan-American Havana Convention on Asylum. Colombia also justified its act, contending that it was a political crime. But Peru refused to let him go from the country and arranged army around the embassy of Colombia to prevent him from escaping. This matter was thus referred to the International Court of Justice. The court held that Colombia was not bound to surrender him, though the asylum granted was irregular since he was a political offender. The second one is generality of practice. But first of all, what is meant by state practice? It is how the states behave in practice that forms the basis of customary law, but evidence of what a state does can be obtained from numerous sources. The obvious examples include administrative acts, legislation, decisions of domestic courts, and activities on the international stage, for example, treaty making. We all know that a state is not a living entity, but it consists of governmental departments and thousands of officials, and state activity is spread throughout a whole range of national organs. There are the state's legal officers, legislative institutions, courts, diplomatic agents, and political leaders. Each of these engages in activity which relates to the international field, and therefore one has to examine all such material sources and more in order to discover evidence of what the states do. The obvious way to find out how countries are behaving is to read its newspapers, which consists of what is happening in the day to day affairs in that country, consult its historical records, listen to what governmental authorities are saying, or and may also peruse the many official publications. There are also memoirs of various past leaders, official manuals on legal questions, diplomatic interchanges, and the opinions of national legal advisors. All these methods are valuable in seeking to determine the actual state practice. So, a custom to be valid, it should be generally observed or repealed by numerous states. But it is not necessary that it is universally practiced. The third one is just cogence. It is an important concept when it comes to international law. Just cogence or compelling law refers to a category of norms that govern customary international law. These are peremptory norms from which no derogation is permitted. A peremptory norm is a fundamental principle of international law that is accepted by the international community of states as a norm and from which no derogation is permitted. This can be modified only by a subsequent norm of general international law, which is also having the nature of just cogence. We can find its mention in Article 53 and Article 64 of the Vienna Convention on Law of Treaties. Article 53 provides that a treaty is void if it conflicts with the peremptory norm of general international law. And 64 provides that if a new peremptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. The peremptory norms of general international law, that is just cogence, reflect and protect the fundamental values of the international community and are hierarchically superior to other rules of international law, and they are also universally applicable. Customary international law is the most common basis for peremptory norms of general international law, as well as treaty provisions and general principles of law may also serve as basis for peremptory norms of general international law. For instance, the laws prohibiting slavery, genocide, piracy, acts of aggression, or illegal use of force are some examples for just cogent laws. Even certain human rights provisions, such as those prohibiting racial discrimination, can also come under the category of just cogence. The fourth one is opinio juris. Opinio juris is actually a shortened form of the Latin phrase opinio juris sive necessitatis, which means an opinion of law or necessity. In customary international law, opinio juris is necessary to establish a legally binding custom. In simple words, opinio juris is the belief that an action is to be carried out as a legal obligation. This is actually a psychological factor, that is the belief by a state that it behaved in a certain way which it was under a legal obligation or had a legal right to act that way. This term was first formulated by the French writer François Genet as an attempt to differentiate legal custom from mere social usage. Its importance was reiterated by the International Court of Justice in North Sea Continental Shelf Case 1969, where it held that customary practice, though it is general and consistent, it is not acceptable unless opinio juris is present.
In other words, it is not binding unless the practice is recognized by international law. Apart from these four ingredients, the custom to be valid, it should also be moral and reasonable.
Thus, from the above discussion, we could conclude that the correct option would be D, that is 1, 2, 3, and 4. At the end of the discussion, I hope that you all would have become clear regarding the various essential elements required for a valid international custom. Do follow the Courtroom Intellectuals for more updates. Thank you.